Okay, hello, my name is Ashley, and today is June 17th, 2021. This presentation has been designed for all of our Russo Law Group clients. Thank you all for being our clients and also for joining us as we talk about the new rules of New York State's power of attorney. So before we begin, I have a few housekeeping items. To help minimize audio distractions, we have muted your microphones. Please submit questions through the Q&A window provided on your Zoom toolbar. We may address them as we go along, but if not, we have saved time at the end for Q&A. We should be together for about 45 minutes, but no longer than an hour. We created a PowerPoint for the program, which we are showing on screen. This session is being recorded, which we will share with you in an email after the program. We always appreciate feedback, so please complete our survey. You will access the survey from your web browser. It should open automatically when we end the session. So if anyone has questions about the housekeeping, just send me a message in the chat window. Okay, at this time, I will turn it over to our managing partner, Vincent Russo. Vincent is the co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs, which was established in the memory of his daughter, Teresa. He's also the founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys. Okay, Vincent, welcome aboard.
Thank you, Ashley. And I'm thrilled to be with all of you today. Really on the cutting edge here with the new Durable Power of Attorney statute in New York, which just became effective June 13th. So with me today for this presentation is our partner, Deanna Ebley. And Deanna is the lead planner in Garden City, Islandia, and Manhattan. So she travels. I appreciate that, Deanna.
Thank you.
And has a focus on the practice areas, elder law, estate planning, Medicaid, special needs, Social Security, disability, real estate. She does it all. And she's on the executive committee of the New York State Bar Association's Elder Law and Special Needs section. And also joining us will be Kim Christian. Hello, Kim.
Hello.
And Kim is a partner of the firm. And I'm thrilled that she was able to get out of a court hearing this morning and be available today. And Kim is the lead planner in Garden City and heads up our Lido Beach office. So for all of those who want to come down to the beach, you just drive down a little further and you can stop in, say hello, and get some ice cream at the Marvel stand. Can't beat it. So today, we've invited all of our clients to this exclusive presentation and a special welcome for our Peace of Mind clients. We're going to cover in this hour what is a power of attorney, what are the benefits of a durable power of attorney, what do I need to know about the new power of attorney law, and should I revise my existing power of attorney? So we're going to go back and forth, Deanna and I, but I'm going to start it off with what is a power of attorney. My hope is that every client has one. And a power of attorney is a legal document that gives someone you choose the power to act in your place when it comes to your financial affairs. So you're not giving up any power, you're allowing others to be able to step in and help you. So Deanna, what are the benefits of the durable power of attorney?
So the major benefits of a durable power of attorney are that by doing this power of attorney, you're naming somebody to step in and handle your affairs on bill paying, which is a day-to-day or a month-to-month thing that you do. And there may be opportunity where you're temporarily unable to do that for yourself. So someone can step in and manage that. You are also giving an opportunity for an individual to manage your assets and income. And some clients have seen this with us when we're doing different things with pooled income trust through Medicaid. We're able to, in a home care setting, manage the income as an example. And also it is an opportunity to do additional estate and long-term care planning beyond what you've already done, that if there's some kind of crisis and, for example, you need home care, we're still able to use the power of attorney to do something and manage your assets in a way that you can get Medicaid home care in your home and still get all the benefits that you're entitled to.
And also for the clients who have more significant assets, the power of attorney would allow for estate tax planning. So
Correct.
that can be helpful as well.
Correct.
So no one should leave home without it. I mean, that's the bottom line. We're all
Primary
vulnerable.
document. It's such an important document. And it's a lifetime document, Vincent. So it's good for your lifetime as opposed to the will, which is your after death document.
Correct. All right, so let's move to the new rules. And as I mentioned at the opening, we have a new New York State power of attorney law. It came into effect on June 13th. And I have good news. I actually think we have a new and improved version of the statutory durable power of attorney. And why I say that is that back in 2009, because of serious concerns of elder abuse, major changes were made in the statute. And it was well intentioned, but it also made the document very complicated. There were two parts to the document, the second part being a statutory gift rider. There were numerous places where you would need to initial or sign. We had different signing rules for one part versus the other. So it was a very complicated, overly burdensome document, very confusing. And in 2010, just a year later, the legislature went back and revised the statute to try to clean it up. But unfortunately, they didn't really do the job. But this time around, after years of work in advocacy, working with the banking industry and the New York State Bar Association, we have these new rules, and I'm thrilled with the new statute. So I'm going to ask Deanna to highlight some of the changes in the new statutory durable power of attorney. And the first change I'd like you to talk about, Deanna, is the change in terms of signing the document.
This is probably one of the biggest changes that I'm most excited about, because we do a lot of planning for individuals who have physical limitations and special needs. And I've definitely done my fair share of signings where the principal, the person signing the document, has had some difficulties holding the pen and actually signing. And the fact that the law is changing to make it very clear that just because you physically can't sign the document doesn't mean you can't have this document is huge to me. It gives the opportunity for, let's say, Mary, who's the one who's signing the document, to give the authority out to Sue. Mary can direct somebody to sign the document on her behalf and say, I'm completely competent, I know what I'm doing, I can't physically hold the pen and sign it, but I would like for John to sign in for my interest to make this power of attorney effective for me, so that Sue can step in and handle all of my affairs. And I think this is a huge step in this law, because we have a lot of clients who have that limitation, and this gives them an opportunity to not have to be forced into a setting that could even go as far as a guardianship to get the same rights that they would normally have just by being able to sign the document.
Excellent outline of how this new provision is going to make it so much more flexible for those who need the help. And I like your example, Deanna. So Mary's the principal, the person signing, appointing the agent, Sue. And then you had John signing the document. So the question I have is, could Sue be the person signing the document?
Sue cannot be this person signing the document, because Sue is being the person appointed to handle the day-to-day affairs of Mary. And so not only can it be Sue signing on Mary's behalf to make the document effective, Sue also cannot be a witness to the document.
So how many witnesses do we need for the new power of attorneys?
The power of attorney needs to be witnessed by 2 individuals. One, it also needs to be notarized, and one of the witnesses can also be the notary.
So it has to be notarized, and then 2 witnesses have to sign. And now we have the flexibility, as you mentioned, where a third party could sign on behalf of the principal if they had problems signing the document.
Correct. And all of that is done in the best interest of the principal, Mary, in our example, because by requiring 2 witnesses and a notary, the chances that someone's going to step in and do something fraudulent to sign this document is much more difficult.
All right, so let's move to another, I think, really good clarification on healthcare management.
So with the healthcare management aspect of the new law, there have been times where clients have asked us how they could go about verifying the bills that they're paying for Mary in our example. And so if Sue came to me and said, I got this medical bill from Northwell and I don't know if Mary had this procedure, I don't know what to do about this. Traditionally, we would have had to tell her, well, you need to get the agent under the healthcare proxy involved, but it's very clear under the new law that Sue, as the agent under this power of attorney, can get medical records to see what she's paying for. So she doesn't necessarily have to know what Mary's medical conditions are, but she can get medical records to verify, did she have the MRI? Was it a CAT scan and not an MRI? And have the conversation with the medical professionals to make sure she's paying for the right procedures.
Deanna, what I also get out of this is that it's important to have both the durable power of attorney and the healthcare proxy. Can you talk a little bit about the advanced directives that we recommend in our office?
So obviously we recommend the power of attorney, and that's why it's important for us to be having this discussion with you today. The healthcare proxy is similar in nature to the power of attorney, except it's in a medical guideline. So in that example, it would be Mary appointing Sue to make medical decisions for her. And in our office, we do those medical documents where the healthcare proxy appoints Sue in our example, and then we supplement that appointment with a living will. And the living will is what spells out for Sue what Mary wants or does not want. For example, does she want to be resuscitated? Does she want feeding tube or IV treatments? All of those things are spelled out in the living will, but Sue has the authority to make those decisions and talk to the doctors about those decisions under the healthcare proxy.
So the living will would act as instructions for the agent to follow with regard to end of life decision making.
Yes. Yes.
All right.
100%.
Okay. Let's move on to gifting. This is a big topic and a lot of nuances to it. Deanna, what are the changes here?
Okay, so gifting is a huge nuance in the sense that we want to make sure we have the most comprehensive power of attorney, but we also want to be able to understand what we're giving somebody the authority to do. So in the previous law that changed on Saturday, it said that if you changed nothing about the document and signed it just the way that the state issued the document, then Sue, in our example, would only be able to take Mary's money and gift $500 a year, which would be gifts to either family for birthdays and holidays or charities. All total, it wouldn't be more than $500 a year. The way that the law changed on Sunday, the minimum gift has been increased to $5,000. So if you took that document and did absolutely nothing to it, you didn't modify it at all, the total gift that you would be allowed to make as an agent, if the authority is granted, because you still do have to grant it, is a cap of $5,000. Certainly, we would recommend a more comprehensive power of attorney, because oftentimes, like we alluded to in one of the first slides, we are doing either crisis planning or estate planning, or we're doing tax planning. And when we're doing those types of planning, we want Sue to be able to gift, and with air quotes in some sense, gift more than $5,000 to help Mary qualify for benefits if that's what we're looking for, or to help save some estate taxes if that's what we're looking for. And so we do the modifications to make that gifting unlimited, but in all instances, in order to gift under this power of attorney, you have to actually initial to authorize that change.
All right, so talk to me about the simplification, because I believe that the new law says that we don't need the second part anymore, the statutory gift writer.
Correct. And we saw in our office all too often that, especially when individuals were going online and printing out forms on their own, they thought that they had a very robust document. And then on occasion, they would come into our office to do things, and we would be restricted on what we can do because of that provision in the old form that was a gifting rider. And so they simplified the document to say we don't need that gifting rider, which is great, because there isn't that possibility that someone's going to forget to add it. That caused a lot of confusion for a lot of people. The new document, the new law, has a provision where you initial to say, I want to change the gifting from the 5,000 to something different. And you actually have to initial that change, but you don't have to worry about adding a completely different document all in itself. There isn't another part to it. It's all part of the same document, and you just have to state whether or not you want to add it. If you don't initial it, you don't add it. If you initial it, you can make the changes you want to make.
Okay, so that's going to make it easier to follow. Talk a little more about the importance of gifting, because some people may be concerned that, putting a gifting provision in the document, but when would gifting come into play and be really important to have the power?
So one example of gifting being crucial is in a situation where somebody is looking for Medicaid, for example, a home care situation. And surprisingly enough, one of the things that clients are shocked by is that just because you're husband and wife and you own certain things jointly, it does not mean you have authority just as husband and wife to make gifts or transfer assets between each other. And so, for example, when someone is married and there's a house and the house is owned jointly and one spouse is in need of home care and they're looking to protect the interest of the house, a power of attorney needs, if the sick spouse needs the care and cannot sign for themselves, we need a good power of attorney to transfer the house from, for example, husband and wife to wife. And that transfer under the law is considered a gift. So it's not here, take everything and I don't want any interest. It's just, I can't own it right now because I need to be able to get these benefits. And so there's a lot of, especially in a husband and wife scenario where you want your spouse to have authority to do things for you. From an income standpoint, you want, there are plenty of people out there who have traditional IRAs that have certain exemptions under the Medicaid laws. And those exemptions only apply if they're being distributed over a monthly basis based on Medicaid's rules, not the IRS rules that you're traditionally taking those distributions on. And you want somebody to have the authority to contact your IRA company to say, I need to change the distribution, because that in and of itself is a huge help for you. If you have a $100,000 IRA and you can keep that IRA in your name and still have the protections and the benefits of Medicaid paying for your home care because you're taking a distribution that Medicaid requires, as opposed to not being able to change that distribution and have a $100,000 IRA and Medicaid says you're no longer eligible, you need to pay privately. That's a drastic, an example of why it's so very important to have a comprehensive power of attorney in place.
Deanna, let's say the agent wanted to transfer assets out of the principal's name to a Medicaid asset protection trust or a trust that was set up to save estate taxes or an irrevocable life insurance trust. Would the agent have authority to do that if there's no gifting power?
So the answer is no. The agent doesn't have the authority to do that because the gifting power having not changed the gifting powers or limiting the gifting powers to 5,000, depending on how you sign the document, you're putting a cap on what you can do. If it's limited to 5,000, that's great. You could put 5,000 in a Medicaid asset protection trust or some other trust to protect for estate tax planning, but 5,000 probably isn't what's going to help you. You're probably looking to move more, including a house, for example. So you definitely want to make sure that the power of attorney meets that modification standard so that those transfers, otherwise known as gifts, are unlimited in a format that we can do whatever needs to be done to accomplish what you were trying to accomplish before you got sick.
Okay, very good. Let's talk about another provision here. And this one's really important. It's clearer now what the requirements are, but it's also, I think, a requirement that every agent should follow because it's the agent's always acting in the best interest of the principal. But there are also third parties that are often involved, family settings. And those interested family members also want to make sure that the agent's doing the right thing for the principal, mom or dad, for example, if it's a child who's the agent. So talk to me about the new record keeping requirements.
So I love that they finally put this in writing and gave some clear guidance, because many clients have always asked us, well, what is my role? What is my responsibility? And this change in the law for record keeping requirement gives that clarity to anybody stepping in that role of the agent or that Sue role in our example. And so what this is saying is that the agent has to keep records of all transactions that they're conducting for the principal or Mary in our example. And that could be keeping the bank statements, keep receipts for anything you purchase on their behalf. You want to be able to, if anyone ever questioned what you're doing and why you're doing it, you want to have a backup as to why, what you've done. And maybe the best way to think of it is, when you're getting ready to file your taxes every year, you want to have a backup to any deductions that you're taking. If it's charitable donations or anything like that, you want good receipts. And this is a way to make sure that if anyone ever audited you, you have those receipts in this example also. So you get a binder, hole punch it, put it in a binder, put it in a box. If you are more of the type A personality that a Excel spreadsheet works for you, that's great, but you want to definitely have that information, because you have to remember the principal is entitled to ask you what you're doing. And so the principal has the right to that information. Somebody stepping in as a successor or alternate agent has the right to know that information. And you want to make sure that it's easy for you to provide that information.
Okay, and if you don't like all those pieces of paper around, you can always scan them and save them on your hard drive, but backing up is very important as well. All right, we're going to move on to another major change. And before we do, just want to mention again that if you have any questions you would like to ask Deanna, and when Kim joins us, you can go into the question and answer box and place your questions in there. And you're all clients of the firm, and feel free that if it's a question that goes beyond powers of attorney, happy to have you ask those questions. We're going to have some time at the end, and we already have a handful of questions that have come in. So let's talk about the banks, the financial institutions. For years, and I've been practicing a long time, if I went back 20, 30 years ago, it was a major problem trying to get a power of attorney accepted by a financial institution or a bank. And then things have gotten better over the last decade, but we still have had issues where a bank may not be familiar with the power of attorney document or come up with some reason why it shouldn't be followed. And the banks also, on the other hand, were concerned that if they actually accepted a power of attorney and that agent took advantage of the principal, that they could end up being sued. So the new change here puts responsibility on the bank to accept the power of attorney, but also gets them off the hook if they do. So Deanna, talk a little more about the new rule here.
So this new rule really stems from this idea that there was no recourse for financial institutions taking their time to make a determination and then having that determination be to reject the document. There was no recourse for the person seeking acceptance of the document. And when you're doing any type of planning on a deadline, whether it's trying to get assets moved to meet a tax deadline or assets moved in order to meet a like a Medicaid deadline, that's a crucial time constraint, and having the banks just sit on it for longer than what anybody anticipates should be an average time can create undue stress for the agents, and it can also create undue stress in general for the person that is asking you to step in, the principal. And so we always encourage that you bring the financial institution your power of attorney in advance of the crisis or the emergency, because we were always concerned about these time constraints. And I still think it's good practice that if you're comfortable enough to do that, let them review it in advance. But assuming that you weren't able to do that or you weren't comfortable doing that, the banks have a 10-day time frame to make a decision on whether or not they're going to accept the power of attorney from the date that it's given to them. And the way that they have to accept or reject that power of attorney is, if they're rejecting it, they have to do it in writing. And when they put it in writing, not only do they have to let the principal or Mary know that they've rejected, they also have to let the agent, Sue in our example, know that they've rejected it in writing with every reason why they would reject it in one document. It can't be that today they say they're rejecting it because you only gave me a copy, but they see on the copy that there's other things that they would reject it for, because that just then starts this wheel of, today we reject it because it's a copy, you bring us the original, and then tomorrow we're going to reject it for something else. So they have 10 days to accept or reject the document, and that rejection has to include everything that they're objecting to. So it's good practice that if you submit a power of attorney and you find that they're not approving it immediately and that they're having it reviewed, you call us and let us know that there's an issue and that the power of attorney has been submitted to a financial institution and that you're waiting for a response back, because having us aware that this issue may be out there will help in the next phases of the financial institution's responsibility, because at the end of the day, they have 2 bites at the apple to decide whether they're going to reject it or accept it. And if they ultimately reject it as a final decision and it adversely affects anybody, and there's grounds to bring any action, you can sue the financial institution for damages.
Okay, and the last thing we want to be doing is having to bring lawsuits, but it does put some teeth in the statute, which is a good thing.
Right. It's
And
accountability.
yes, and the good news is that when clients have signed the statutory durable power of attorney that we draft in our office, we rarely get any pushback from the banks or the financial institutions.
Correct.
So it's just something to be aware of. If you go into a bank and for some reason they say they're going to review it or they want additional time up to that 10-day period, immediately call our office. And we probably can just, we can get on the phone and probably just get them to quickly accept it because it would have been executed properly. And so that's a helpful tip for all of you just in case. But as I said, the good news is we rarely get that call.
So now, Vincent, now I've given everybody the new rules and the highlights. So now what do they do?
Yes, the big now what question, and I'm seeing in the Q&A questions that I think we'll be addressing in the next minute or two to answer some of those questions on the now what do I do? Okay, so if you have an existing power of attorney in place, it'll be grandfathered. It'll continue to be valid under the new law. So I would say that don't be concerned that you have a family member who signed the power of attorney. Unfortunately, they may have Alzheimer's or dementia and now lack capacity to change it. They don't have to. That power of attorney is going to continue to be valid. So let me just talk a little about reasons why you may want to update it. So if you have an existing power of attorney, I would say it's a good time to review it in light of the new law. And it may be that you want to change who the agents are, or you want to think about appointing successor agents if you haven't, or changing out the successor agents. So it's always good to look at all your estate planning documents at least once a year and make sure these appointments are in line with your current desires. Another reason to update would be that if your power of attorney, so we may have a client who came in with an existing power of attorney before they became a client of the firm and didn't revise it to be more robust, or the client felt that when they did the power of attorney in our office that they wanted to be more restrictive in allowing the agent to make gifts, and now perhaps they feel more comfortable. I would say a reason to update the power of attorney is to have the most robust protective language in there to allow for gifting, establishing trusts, and to implement crisis planning, as Deanna alluded to with Medicaid, or estate tax planning. So those would be good reasons why you should consider updating your power of attorney. Now, some of our clients are concerned about a document being old. I'm not sure how old is, because as I get older, the age I'm at doesn't seem as old as I thought 10 or 20 years ago. So we'll leave that to your subjective interpretation of old. But if you have a document that you feel is old, 3 years old, 5 years old, 20 years old, and are concerned that it may not be accepted, I'll say as the lawyer, the law provides that your power of attorney, once properly executed, will be valid for your entire lifetime unless you revoke it, or a court revokes it. So you don't really have to worry about the legality of it, but then there's the practical side. The practical side is I walk in and there's a new teller every 3 months at the bank, and this new teller who you don't have a relationship with, you hand them the power of attorney, And if it's an older form, they may not be familiar with it. And then they're going to send it up to legal department. And hopefully the legal department will bless it, but then maybe they come up with some reason why there's an issue here, or the financial institution. So if you have an older document, it might behoove you on a practical level to update your quote unquote older advance directives, power of attorney and healthcare proxy periodically. So another reason, legally you don't have to, on the practical side it may be helpful. All right, so we're now going to take some questions for 5 or so minutes, and then we'll have a conclusion. We'll bring the webinar to a conclusion. All right. So we'll start with a question, and let's put our webcams on, and Kim, join us. So I think the host has to put the webcams there. There we go. Okay. And let's see here. I cannot start my webcam without the host. Okay. So now I think I can do it. Okay, great. All right, Kim, we're going to have you address the first question from Janice. That she's pointing out that this is a change in the New York law. Is there reciprocity or similar laws in Connecticut? So I'll ask 2 questions. One, if I have a power of attorney executed in New York, is it valid in Connecticut? If I have a Connecticut power of attorney, would it be valid in New York? Those are the 2 questions.
Good question. So the way the law stands is that if you executed this document properly in the state or the jurisdiction that you lived in at the time, then it is valid in another state. That's the legal answer. There's also a practical answer. If you are moving to a state, if you're going from Connecticut to New York or to New York to Connecticut, it is good practice to re-execute the power of attorney to conform with the specific nuances of that state.
Okay, so then on the practical level, it would be because someone in New York is going to be familiar with the New York form and not familiar with the Connecticut form. So it's almost a guarantee they're going to send it up to the legal department, and that could create some issues.
Yeah, it's your seller example, right? That maybe they didn't understand something.
Now, also, Kim, what would we do or recommend with the snowbirds who were 6 months and 1 day in Florida, Arizona, North Carolina, and then the rest of the year in New York? And even though they call themselves New Yorkers, they've got dual residency. So, which state do we pick, or do we do something else?
Yeah, we recommend that you actually execute a power of attorney under the New York state laws and also one under the other state. So in your example, if it were Florida and New York, you would do 2 sets of powers of attorney, one under New York law and one under Florida law.
Okay, excellent. And as to the nuances of the New York law, I don't think any of us on the panel can speak to the laws in Connecticut. Would that be fair, Deanna and Kim?
Fair.
Yes, that's fair.
Okay. All right. We got a question here, Deanna, from Sam, who wants to know if you can have 1 or more agents.
So yes, you can have 1 or more agents. I would at the very least encourage an agent and a successor agent. And the reason why I would recommend an agent and a successor agent is, what if something happens to the agent that you've named, or they don't want to act, they've decided that it's too much for them, they need to step down. You don't want to be in a position where there's no one named to act on your behalf, and you are not competent to sign a new document. So at least if there's a successor agent, somebody's available to step in, and again, you're avoiding that guardianship proceeding.
All right, now, piggyback off that question, Julie asks, if I name joint agents, can they act separately? And maybe you could speak to the new change in the law.
So if you name joint agents, there's a provision of the new law that if you want joint agents to act separately, you initial a spot on the document for them to act separately. If you don't initial that spot, then those agents are going to be required to act together at all times.
Okay, and the new law that on joint agents acting together, the provision regarding that even though they're joint, you can initial so that if you go to the bank, you only need one.
Okay, and yes. So there's also a spot on the document. So when you name, if you name two people and you say that they have to act together, and we see this a lot with like brokerage houses where it says that they can act together, that they have to act together, and brokerage houses at times don't want to have to deal with that need for two signatures. The new law allows for you to authorize the agent to delegate their authority to the other agent. And so essentially you say they can act together, and then you name Sue and Kathy to act together, and Sue can delegate her authority to Kathy so that Kathy does all the actual acting and signing of everything.
Okay, Kim, I got a question from Jack. How do I revoke a durable power of attorney?
Well, you can revoke a power of attorney by signing a revocation document and also, simply ripping it up. But what is important is that you contact all the financial institutions that you provided the power of attorney to let them know that you have revoked this. So you want to revoke it in writing. You want to let the financial institutions know that you revoked it. And you also want to let the agent under the power of attorney know. So you want to give notice to that person that this power of attorney is no longer in effect.
So I think from what you're saying, it's important to know where your original powers of attorney are. If you've made copies and given them to the banks or financial institutions, keep a record of it. So when you revoke, you can also notify them as well. The other way to revoke is by signing a new power of attorney and in the document, revoke the prior power of attorneys. So you can do it in a separate document, as Kim mentioned, or you can actually do it in a new power of attorney document.
Right, and even in a new power of attorney, though, you still want to let the previous agents know that it's been revoked so that they are not acting and not knowing that.
Okay. Let's see, we got a couple more that have come in. Corinne, longstanding client, if the principal is temporarily unable to act on her own behalf, how does she limit the agent from continuing to act of her behalf when she resumes normal activity? So a power of attorney, when it's executed, doesn't mean that the principal is given up the right to make decisions for themselves, financial decisions. So it's really an enhancement where they're allowing someone else to be able to do that for them. So if someone was temporarily out of commission and had the agent acting on their behalf, and now they're back in place where they can manage their own affairs, they would simply instruct the agent that they're back and able to make these decisions. And it would be unnecessary for the agent to make those decisions. If that agent continued to make those decisions, then I think we're in a revocation situation where you would have to revoke the document and legally terminate the rights of the agent under the powers that were given to the agent under the power of attorney document. All right, Kim, talk to us about what happens if you don't have a power of attorney and you need Medicaid, or you need to have your bills paid. What happens?
Yeah, so as Deanna mentioned earlier in the program, no one has the legal right to make financial decisions for you if you don't have a power of attorney, even including your spouse. So in some instances where that's the case and a power of attorney was not executed, unfortunately, a person's loved one can end up in a position where they have to petition the guardianship court to get permission to help them. So now you're in a situation where you're in a court arena petitioning to become a person's guardian, when if in fact they had the power of attorney, then that wouldn't have been necessary.
All right, so a guardianship proceeding, do we want to avoid that? Is it, or is that something that, okay, if you need to do it, it's not a big deal?
Yeah, it's certainly something you want to avoid. It's time, it's money, it's stress, right? So all of those things, if it can be avoided, is very important, and you can do so by executing a power of attorney in advance.
Yeah, I mean, a guardianship could be over $10,000. It could take months before a legal guardian is appointed, so that creates issues. You can't pay bills or manage assets. So it's a great process that we utilize when families are in crisis if they don't have the document. But we're urging all our clients to absolutely have the document and avoid a guardianship. We got a question from Robert, and it may also be relevant to others, questioning perhaps the validity of his existing document. And I would say the way we can address that is by your contacting Ashley after the meeting, ask for Ashley Glover, and send your power of attorney in to us, or give us a call, and we'll look at the document we have in our system, and then we can tell you definitively where you stand with that. As we mentioned, the power of attorney lasts for a lifetime. So there was a question about if I have one that's 2 years old, is it still valid? Whether it needs to be updated or not is a different question. Here again, if you send us, anyone who's attending has a concern about their existing power of attorney, contact us. We'll look at your existing document and we'll let you know. So I think that does it for the questions today. Thank you, Deanna and Kim. And we're just going to move to what we can do for you. So some of you are on the phone, have joined our Peace of Mind program. And I'll have Kim talk about the program in a minute. And if you're in the Peace of Mind program, then there's no charge to update your durable power of attorney. Typically, we've been charging $1,000 when doing a new durable power of attorney. So that's a significant savings, and there's no charge because you're in the Peace of Mind program. If you're a client of the law firm and not in the program, then we believe so strongly in every client having the most comprehensive durable power of attorney available, and also the new form, we're offering a discounted fee. So if you have an existing power of attorney with us, we will revise your existing power of attorney for $250, or for another $100 if you're a married couple, it would be $350 for the 2 documents. Another alternative or situation might be that you don't have a power of attorney document. And if that's the case, the fee would be $450 or $550 if you're married. And then lastly, if you join the Peace of Mind program and want your power of attorney revised or created because you don't have one, then there would be no charge. Now, the Peace of Mind program is really a client care program. It's an ongoing program where we're proactively making sure that your estate plan is up to date, and we're available every day of the week to help you if you needed help. So we charge an annual fee of $750, And Kim, can you talk a little bit about the program itself?
Yeah, I agree with you. I encourage everyone to join this program. It is client care. Our program gives members the security of knowing that their attorneys and staff members here are available to answer your questions. And as Vincent mentioned, at a flat rate for the whole year. And some of the highlights of this program, as I mentioned earlier, were the telephone conferences. So if you have a question that comes up, whether it's related particularly to your matter or you have perhaps a real estate question or something else, we're able to take that call for you under the program. You get an annual review with us. So we're making sure that we and you are on top of everything and walking through any details to your plan that need to be followed up on. Some other highlights, which I love, is the share file. So, you know, I know myself, sometimes I'll wake up at 2 a.m. and I'll say, you know what, did my documents say this? Or I need to look at this document. You will have instant access privately to those documents, and you have the ability to share them with family members if you want to. And of course, you get special timely information bulletins on perhaps new law changes such as the power of attorney and things like that. So we make that a priority for members of this program. And there's also financial savings that goes along with it, discounted rates for changes to certain documents. I know the advanced directives are done and updated at no additional charge. So this program really is an excellent program to keep in contact with your attorney, to feel the freedom to contact us at any point and have that flat rate associated with it, and to get the latest alerts as to what's going on in the legal world.
Right. And our thanks so much, Kim. And our Peace of Mind program is headed up by Deanna. So Deanna, I know you're a strong believer in the program. Any additional thoughts before we wrap it up?
No, I mean, I think Kim did a great job. It's really your opportunity to have us fully available to you and not stress about asking that question that you think maybe isn't that significant. I encourage you to call with all your questions because the insignificant one may be the most important one.
Absolutely. All right. Well, hopefully this has been helpful to all of you in understanding the new change with the power of attorney statute. As I mentioned up front, I'm feeling really strongly that the power of attorney is a better document today, this newer version, and the law is stronger and more protective of your rights. And so we're available to help you. And beyond the power of attorney, we want to make sure that your estate plan is up to date and that we've done everything we can to protect you if you have concerns about long-term care or estate taxes or how to leave assets in a protective way for a family member. So thank you so much. Looking forward to a really beautiful summer. In the next couple of months, we'll be enjoying, hopefully, the good weather here in New York. So I hope all of you will do the same. Be well and be safe. And Ashley, any parting words before we close?
Sure. Thank you for the presenters. So Deanna, Vincent, and Kim for your presentation and answering questions. We appreciate all of you for joining us. And I personally look forward to speaking with those of you who do choose to take advantage of our offer. Give us a call. Finally, as a reminder, please complete the survey. It will pop up on your screen momentarily, and we look forward to reading your feedback. And that's all. Have a nice day, everyone.
Take
Have a
care.
great day.
Bye.